I think I'll start now. Good morning, everyone, and welcome to today's session on representation agreements and temporary substitute decision makers. Before we start the session, I would like to acknowledge that Legal Aid BC's head office is situated on the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I would also like to acknowledge that many of you are joining us today from many places, near and far, and acknowledge the traditional owners and caretakers of all those lands. Welcome again. And today's session is a busy session. I must say that it's a full session. Along with me in the support staff, with our speaker today is Alessia Mordini and Sarah Chow. I'm really thankful to both of them to run these sessions with all their dedication and hard work since the COVID started. All the questions will go in questions and answers, the Q&A box, and I will monitor the Q&A box, and I will interrupt the speaker as I will see a possible time to do so. So on that note, and it's my pleasure to introduce our dedicated, honest, and always being flexible. I think many of you know her, Kelly Melnick. Kelly is always there. Whenever I ask her, she's always there. And I really like her positive attitude towards learning and towards teaching. I don't know, partly she's with Thompson Rivers University. She have that sort of attitude, or she's just like that, but I love her attitude and dedication towards that. She's a supervising lawyer with the Thompsons River University Community Legal Clinic. Kelly was called to the bar in British Columbia in 2017. She has been with the TRU clinic for a year now, and prior to this position, Kelly worked in private practice. Her areas of practice included advanced planning, issues relating to the elder law, residential tenancy, family law, and criminal law. Kelly is always passionate about access to justice and assisting low-income clients who would otherwise not be able to access legal services. Along with me, please join hands to welcome Kelly Melnick in today's session. And thank you, Kelly. Thank you again for joining us today.
Oh, goodness, Baljinder. I'm not going to be able to get out of my office now. Thank you for those really kind words. As Baljinder said, I always love talking and doing presentations about topics that impact broad sections of society, in particular those lower income. But I especially love talking about advanced planning and anything elder law or anything that impacts vulnerable clients. So representation agreements in particular are very, very important. And so I'll just say I do have the list of a bunch of the pre-submitted questions. And so I'm going to try and touch on them as I go through. And then hopefully near the end, if there's any that I haven't answered or any of the questions that arise, then we can take some time to answer those questions. So what I think will be helpful, I just also want to point out Carrie Priddle, who was going to be joining us today. She's not able to make it. She got called into court, so unfortunately she can't join as well. So it's you're saddled just with me, which hopefully that's okay. And before I proceed any further, I would like to acknowledge that I am on the traditional and unceded territory of the Tecumseh people here, and very happy to work and play on their territory. If a dog pops into the session, her name is Stevie. She's not jumping up on me right now, but she is here. So I'll apologize now for Stevie's appearance if she makes one. So I'm going to jump into it and hopefully answer all the questions that we get as we go. And if there's something that does tweak your interest, like Baljinder said, just throw it into the Q&A and we'll try and answer it in real time as best we can. So without further ado, representation agreements and temporary substitute decision makers. Now, what precedes all of this is capacity. And our understanding of capacity in the legal profession is very different than that for the medical team. And so our concerns as lawyers or people assisting clients in the legal side of the representation agreement or questions about representation agreement is whether or not our client is able to understand and appreciate the contents of the decision that they're going to be making. And so capacity, just generally in a kind of a brief overview, what we're talking about is the subject, the decision that they're making, and where that fits on this sliding scale here. I've built this sliding scale because I've done this type of a talk a number of times. And I see Chris has asked, yes, the PowerPoints are going to get sent out, so don't worry. So the sliding scale is kind of helpful, I find, to make sure that people understand that different decisions warrant different levels of capacity for our clients. And so marriage, for whatever reason, even though it is a very important decision that can have huge repercussions throughout your life, those decisions are at the very low end. And so marriage is a lower scale capacity requirement. Then we go into basic contracts. Do I understand what this contract is? Am I entering into it on my own free will? And do I understand the effects of that? So that's kind of, as we start moving up, section 7, is the lower level, and I'll explain the differences between the section 7 and section 9 in a little bit. But if the person is able to express themselves in whatever method that they need to, can they express themselves that they want somebody to be making or helping them make their decisions or stop making decisions for them? Does this person, understand or demonstrate kind of a choice or preference for who's making these decisions, and can they express themselves or disapproval or approval of somebody else, and that they can make that representation agreement or change any of the terms in it, and is that relationship one that there's a characterization of trust? And so that's kind of where the section 7 fits. Section 9, we're getting to that higher level of capacity and the impacts and the repercussions of making that representation agreement. And so that's kind of where that really starts to fall into it, is does this person really comprehend and appreciate the potential consequences, more so than just saying, I want this person to help me make decisions. So we start to see that now. Then we really start to get into that higher level, power of attorney capacity level, and that's and it's akin to a section 9 in that what does this person know what they have? Where are they banking? What are in their bank accounts? What assets do they have? Who do they owe any duties to? Do they understand that this person that they're appointing as their attorney could really, misuse that authority, and as a result, the adults or the client's assets could be diminished because of that, and that they can revoke it at any time? And so there's that higher level. And then when we talk about the will, for whatever reason, it's funny, I always find this really an interesting aspect of this area of law, is that the will, is treated as the utmost, the highest level of capacity required, that testamentary capacity. And why I find it so funny that it's the highest is because, well, this impacts you after you're dead. So, it's not real and a major impact on you in person, whereas a section 9 rep agreement or power of attorney really does have a great impact on your personal being while you're alive. And so in my mind, I think that would be more important than a will. But so for a will, what do you have? What assets do you have? Who do you owe obligations to? And then from there, how do you want to give it to them? And so, that's just kind of a brief overview of capacity from our perspective and how we're going to be assessing it. And I will note that this is something that's done day of, right? So for people who are working with clients that are potentially, say there's, I mean, the most common one is definitely a dementia diagnosis of some sort, whether it's Alzheimer's or neurocognitive, that depending on the state of the diagnosis and where the illness is at, capacity can happen on one day, but not the next day. So we can sign a document, say on a Monday, but Tuesday they're back into whatever state, a reverted place, and they can't sign. Or you'll have a client who's on medications that greatly impacts their ability to make decisions. And so sometimes if you know you need to get a document done, and you've gotten clear, coherent instructions, and then they're on a medication that impacts that, they might have to come off the medication for a little bit just so that you can get that document done and then back on again, right? So it's very circumstantial, it's very subjective, and that's why it's a legal assessment. And so sometimes that's hard to explain to doctors and things. No, I see that, Trisha, I see that question. So I'm going to get to that. It's an interesting tension. I will definitely touch on that in a little bit. I will say this, doctors do, we do often want to talk to the doctors. And the reason why we will talk to doctors or care teams is that they are, we like that evidence, right? But it's not a be all end all. And there's actually a case that was just issued by, I think it was the Court of Appeal. I can't, no, Supreme Court, where the doctor's evidence is important and it's considered, but it's not the determinative factor. And so realistically, like if I contact a doctor, what I'm trying to find out is, okay, so what condition is it exactly that they're suffering? What are the symptoms? What are some of the impacts to them? So I know what I need to be aware of. For example, if they've had a stroke, I've had a client who, for whatever reason, the pathways in the brain between, like for communication, something had disconnected. And so I would say, okay, can you tell me what year it is? Can you tell me what year it is? They would say blue, right? And so the words, like she understood what I was asking, but the words weren't coming out. And so we figured, I spoke with the doctor and he explained that the situation was it's not a comprehension issue. It's the verbalization of the answer. And so in that scenario, we figured out a way to make it work, that I could get instructions and confirm instructions and confirm capacity by writing things out. So for example, I put the 4 seasons on a paper and I asked the client to circle what season we were in, and they were able to circle the correct season. And so there's ways that you can work around it, and you have to kind of, as a lawyer, I think, be creative in that regard. And I think that sometimes the issue isn't so much a capacity issue, it's a comprehension issue. Sometimes even for us with some of our clients, we have a lot of clients that, you have to use simple language because, and it's really fun watching students try to do it, because they forget that if you say real property to somebody, you have to explain what real property means. That's your house, anything where with a land interest, or, you own your condo or something like that. You're not renting, so you have to explain some of these terms of art to the clients. So yeah. So that's capacity in a nutshell. Now, gotta go back one. Okay, so representation agreements. Now, I noticed that there's a lot of opportunities to discuss powers of attorney in this conversation. For time's sake, we're keeping it pretty limited to representation agreements and then the healthcare consent, so the temporary substitute decision maker. What I will say is to explain the difference, because I know that there's a bunch of the questions, like the pre-sent questions, kind of talk about powers of attorney and rep agreements. What I will say is that powers of attorney if you think about yourself as, so take me, I've got my purse and I've got a wallet and a phone and all that business on me. If I take all that stuff, the purse, so, bank cards and phones and all that stuff, and I put it to the side, the power of attorney deals with that stuff. So your legal and financial decisions only. The representation agreement deals with me, the person. What am I wearing? What kind of medical care am I getting? Where am I living? So these are things that the representation agreement is what's dealing with. And sometimes those documents, those people have to work, if you have a different attorney versus a representative, they sometimes have to work together because the attorney has to pay the bills, sign the contracts, but the representative has to make the care agreement or care arrangements and things like that, right? So we do have to make sure that we're very clear about that distinction. So there's the stuff and then the person. And so today we're talking about the person. Now, Section 7 representation agreements, it's kind of a rudimentary way of thinking about it, but realistically, when we talk about the Section 7, Section 9, to keep them kind of organized, and at least for me, in my mind, Section 7, less capacity, less authority, and it's a lower number, so less marbles, so less capacity. So that's the Section 7. Section 9, you have a bit more marbles about you, you have more capacity, you give more authority. So less, more. So that's the simplest way when you're trying to, I find, explain it to clients, what the difference is. That's kind of where I draw that line there. Now, I think that there's been a few Q&As. Baljinder, do we want to answer a few questions right now, or?
I don't have any questions.
Okay.
There's one question now. How is Section 7 a stop-gap measure? But before you start answering these questions, I have one request for all the participants. Can you please post all your questions in Q&A? It's very hard for us to track both the chat and Q&A. I hope it'll be comfortable for you to post questions in Q&A from now onwards. Thank you. So the question is, how is Section 7 a stopgap measure? Thank you, Kelly.
Yeah. Okay. So I'll jump to that question. I do see that Mel S here had a question about how can a lawyer assess cognitive ability. So it's not so much that it's a cognitive assessment. So whether or not a person can care for themselves or their finances, that's a different assessment. What we're looking at when we talk about signing a representation agreement or something like that is, does this person understand what this document is? Are they entering into it on their own free will? So it's their intention to have this document, not because someone else has told them that they should. And really what we're wanting to look at is not so much their cognitive functioning, but in that discussion with them, we're wanting to find out, okay, this is, you came to us to have somebody make medical decisions, right? Yeah. And this is the person you want. And, and so our job is to assess their understanding of the document that they're looking to sign, whether they want to do it on their own free will, if somebody has been influencing them to get this document done, and probing that. So as a junior lawyer, it's something that I think it's really important to shadow a more experienced lawyer in this practice field, to learn how to ask those questions, what to spot as something that's not quite adding up. I mean, there's a basic level of cognition and things like that, but it's a matter of determining if they understand and appreciate the document they're signing and the potential consequences of that, and letting them make the decision on their own free will. I mean, it's kind of a hard thing to explain to students, that sometimes we're not going to agree with them, with our client about appointing somebody, or, but as long as we've told them what the possible repercussions are and satisfied ourselves that they understand what we're saying to them and that they can appreciate those consequences, then it's their decision to make. And so there is that's why I say it's a hard thing to sometimes explain to social workers or to doctors that, look, what you do is this, and it's important, and I sometimes want to talk to you about that. But what I really, when it comes down to it, the courts, when something's being looked back at, the courts will look at whether or not we as lawyers went through a proper assessment of the legal capacity to understand that document. So it's kind of and it's not an easy answer, but it's definitely a skill that gets developed, just like with young doctors to older doctors, right? Like it's that kind of thing. Okay, now Section 7 as a stopgap. Let me explain that. Okay, so when you have more capacity to enter into a Section 9 agreement, at that point, you are like 99% likely to also be doing a section or a power of attorney. And so you'll see that I have no financial ability is available within the Section 9 representation agreement, whereas there is day-to-day financial representation or day-to-day financial assistance that you can give your RA or your representative in your Section 7. And so this kind of fills in a little bit of this gap in protection, where the person hasn't fully lost capacity, but they don't have the legal capacity to enter into a Section 9 or a power of attorney. So the Section 7 kind of fills this little bit of a gap in protection, because if you don't have any capacity, you can't do a Section 7 or a Section 9 or a power of attorney. If you have some capacity, it's still, you can meet that test of, I do want someone to help me make my decisions. I want this person to do it. And they're able to express, approval or disapproval of people or things. Like there still has to be some level of capacity there with the Section 7. But it's not enough for the Section 9. So at least somebody can be appointed representative for that person to approve of a care plan, to help out with the banking, to help make personal care decisions. They can make major or minor healthcare decisions, but they cannot choose to have the adult restrained or moved, which is something you can do under a Section 9. A Section 7 representative cannot refuse treatment to preserve an adult's life, but you can give that authority in a Section 9, right? And so really what you're doing is you're allowing somebody to come in and make some decisions. They're just not the most serious of decisions for that person in a Section 7. So at least there is somebody that the care team can go to under a Section 7. So there still has to be a little bit of capacity, enough to understand, that they want someone to make decisions for them, right? Whereas the Section 9, we have a much higher level of capacity because we're giving so much more authority away to the representative. And so, they can say yes or no to that life-preserving treatment under there. They can have that person restrained or moved, or even interfere with the adult's religious beliefs if that authority is granted. Say it's a person who does have a child or is a guardian for a child or even another adult, you can give that your representative the authority to make temporary arrangements for care for those people that the adult is a caregiver for. So there's all sorts of distinct things that you can put in and pull out from your Section 9 representation agreement, but it's a much higher level of authority that you're giving, and that's why you have so much more assessments, a much higher level of capacity required than Section 7. Yeah. Let's see. Yeah. Yes, Eric. Thank you. I hate this problem, and I'm going to I'll tell you what my understanding of the issue. So Eric has asked, suggested the Rep 7 agreement when a 9 and a POA aren't possible. Where that is this is a problem is banks in BC often don't recognize and are unfamiliar with the Section 7. Any advice? The sad thing is the banks are allowed to do what they want. And my understanding of the issue is that a lot of the bigger banks, the national banks, they are based out of Ontario, and so they are much more familiar with Ontario law, or they have their own internal powers of attorney that they want clients to sign, and they charge you $50 to do that. And so what that is created as a problem where you can do these Section 7s, but if the bank doesn't recognize it, what's the point? I have discovered that the credit unions particularly are familiar with Section 7s and are more cognizant of that financial authority that they grant. And so other than saying, you know, open a bank account with a credit union, sadly, I don't, there's not really much that you can change that other than, you know, getting into Toronto and talking to the legal team there. And I don't think they really answer those questions. Living wills, I'm seeing 2 questions here. I'm just going to jump on those real quick. Living wills are not really a thing. They're not in BC. Living wills, it's kind of an old thing that, you know, maybe realistically what care providers, and I'll talk a bit more about advanced directives in a little bit. What you're looking at is either an advanced directive or representation agreement. Otherwise, that living will really isn't anything. The only other document that the care team would look at would be the most medical order for scope of treatment, and that's something that a person does with their doctor. It's not a legal document per se because, well, we don't do most forms. That's an interior health or whatever your health authority is. They all have their individual health most forms. And those will refer to representation agreements or what have you, but they don't, like, living wills don't intersect with rep agreements. It's not a thing that really exists here. You do the representation agreement or you do an advanced directive, and I'll explain a little bit more about advanced directives in a slide or two. But yeah, I've heard of living wills a lot, and they're not active here. So there you go. Okay, now we kind of talked a lot about this already. So we've got capacity, the types of decisions that can get made, and the ability to refuse care is the big one, as well as financial abilities. If a client can do Section 9, then you do the Section 9 and a power of attorney. But financial abilities in particular are really what kind of differentiate. So if a client has a lower level of capacity or has some type of disability that impacts their ability, their decision-making abilities, what we try to do is try to be as supportive as we can and see if there is a possibility for Section 7, and hopefully they bank with the credit union. It's really frustrating. So my issues, like from the legal perspective, when we're looking at, let's see, we've got to, yeah, honestly, Eric, I think part of it is, I think a predominant part of it is a lack of knowledge, or a lack of resistance to care to find out the difference. Because I've even had some clients who have gone in with a valid power of attorney from a lawyer's office that has said they didn't want to take this one. They made us sign a new one with them, like their own one. So honestly, it's every bank is like to, and sometimes even branches. When I was practicing in Lumby, we had great relationships with the banks, and it was never a problem with the Lumby branches. But if clients were out into Kelowna or Vernon, sometimes it became an issue. So honestly, like branch to branch and bank to bank, it differs. It would be great if they could all recognize it, but yeah. Okay, so issues from our perspective when it comes to these documents is you know, capacity. We always want to make sure that person has the ability to enter into the agreement. Eric's hit on the use of the Section 7 representation agreement. Sometimes it is very difficult to get people to understand that care teams and a lot of care homes are very familiar with these Section 7s, and so it's much it's a lot handier. I actually was on the phone with a social worker with the long-term care facility yesterday about use of Section 7 representation agreements. So, you know, I think it's great that they're out there and they help fill that void before somebody's fully gone out of the picture. So we get a lot of confusion about powers of attorney versus representation agreements. We have so many people that will say, oh, you have a power of attorney, I don't need a representation agreement, or, oh, my friend so-and-so back in Alberta, they just have a power of attorney and they're fine. It's like, well, Alberta's different than here. They don't have representation agreements. It's very unique to BC that we've separated them out into two distinct documents. But, you know, I mean, really, like when we're talking about, you know, if there's land that needs to be dealt with, if your client has land, then they're going to need a power of attorney. The representation agreement's not going to give any kind of an authority to deal with the land. So, you know, it's kind of one of those things where you have to look at the client's needs. If they have the capacity, rather than referring Section 7, definitely try and push for the 9 and a power of attorney while they still can do it. Yeah, and then how does it fit with that representation? So that is, you know, we jumped ahead a little bit on that last slide answering those questions. Is I think some people get confused. They call an advance directive a living will, and realistically, the advance directive, it can be done in conjunction with a representation agreement. So for example, if there's very specific care instructions and they don't care who's making that decision, they just want to tell the doctors, this is what's going to happen in this scenario. That's the advance directive. That's the benefit of an advance directive. It supersedes, it binds your representative to follow those instructions. And it binds the care team to follow those instructions. So there's no dispute. This is what the care I want is, and that's what it's going to be. And we have some clients who really do have very specific care preferences, and nobody in their lives to make that decision. And so they're very concerned, you know, this is where you get some people talking about that living will. It's not the living will that they're actually wanting. It's an advance directive, because that's what's recognized here in BC. And it's kind of like a living will, right? You know, I'm of sound mind and I want this to be my care process. And so the advance directive is what's going to guide that scenario when you don't have a representative, but you do care about what decisions are made. So let's go to the next one. All right. So we have the patient, the family member, the representative, right? So when we talk about care decisions, what we're really wanting to talk about is whether or not who's going to be the one that's going to make the decisions, the representative, the patient, the family member. First of most important, when you're talking to clients about representation agreements, really what we're wanting to find out is if the doctors, you know, who are they going to go to? Well, the first person they want to go to is the patient. If they can get directions straight from the patient, that's who's going to be the one to give that authority. The presumption is that the patient always has capacity, but then they have to do an assessment of whether there's anything that suggests otherwise, right? Communicating is not always an indicative of capacity, right? Just because someone can speak doesn't mean that they have capacity, but also on the inverse, just because somebody cannot speak does not mean that they lack capacity, right? And so, like I was saying earlier, I had the one client who couldn't communicate verbally, and so you have to look for other ways to do that. And so what a doctor's looking for, what they want to see when they're assessing capacity, and this is all found in the Healthcare Consent and Care Facility Admission Act of BC. section 7 and 8. And so the healthcare provider has to determine if that patient understands the information that's being given to them for their care treatment, and that the information applies to their situation, right? And so if they're looking to see to get that consent, you know, if this person is able, you know, to understand what they're being told, so that the healthcare provider is the one that has to communicate with the adult in the manner appropriate to that person's skills and abilities, right? So again, we're always looking at what works for that person, and then they have to be able to demonstrate an understanding of that healthcare. So I see we've got a question. Yes, Sandra, I'll tell you why. Yes, the advanced directive does supersede the representation. It guides, right? It's one of those things. So if you've got both a advanced directive and a representation agreement, if an adult has both of those, regardless of when, they have to make sure that they understand that like there's a subsection, but if any instruction in the advanced directive that relates to a matter of which the representative has decision-making authority, the instruction referred to in the advanced directive is treated as the wishes of the adult expressed while capable, right? And so that's what's going to guide. Now, an adult in their representation agreement can state that the healthcare provider may act in accordance with those instructions without the consent of the adult's representative. So they don't have to go to the representative to make that decision if the advanced directive gives them the authority to do so. So you can tell your doctors through an advanced directive that that's what's going to happen in this scenario, and you don't even have to talk to the representative about it. They're just going to act on it, right? Now, if it's not specifically laid out that the care team can act without that consent, they're going to talk to the representative, but the representative is meant to treat that advanced directive as the stated wishes and to follow those wishes. They're bound to follow the wishes of their the person that they're acting for. And so it's really important that has to, you know, I think what's the point of doing it if, you know, what's the point of having a representative? What's the point of having an advanced directive if you're going to be told, well, your person can make the decisions without following your wishes, right? And so you really have to, I think it's really important for clients to understand that this is what their wishes are, and they're going to be followed. So that's really important. So then if we don't have a patient who can give consent to care, then, you know, that's where the representation agreement, the advanced directive, and then temporary substitute decision maker comes in. But what's the hierarchy there, right? So when we start looking to that part of it, the representative is going to come first, right? And so when we talk about representatives, we want to say, okay, so it's not going to be a power of attorney. Don't let the attorney jump in, right? They're dealing with the staff. I'm going to deal with the person. And a lot of times you start to get a little bit of fighting about that. So it's really important that people understand that difference from the outset. So we're looking for the representation agreement. I know there was a question about NIDIS in that in the preset questions, and so I'll just jump to that. So for those that don't know, NIDIS is a registry where you can submit those documents ahead, and then you can give access to care providers or to certain people and groups. I think it is helpful in that end. So I'll preface this by saying I don't get to, like, as a legal provider, I can be given access to somebody's personal planning registry documents. I've not had to access them because usually I'm executing them, right? And so I don't usually have to deal with them on that back end. So I don't know what it looks like, but I understand that it is something that people really do like to use. So, you know, it's kind of a, that is, yeah. So the question about, is there a place that the person can have the advanced directive file? So two things on that. So NIDIS, I think you can get all that stuff uploaded, and I think that's really helpful. My understanding with the way a lot of doctors' offices have moved, even walk-in clinics, is that a lot of the medical records are now digitized, and so these things can be put onto the internal systems for the doctors. I think anytime you can get it into a medical file, it's really helpful. Or even at, you know, if you can log it, like if you've got a patient or a client that has been at the hospital, you know, for things in and out. I mean, I don't even have a family doctor here in Kamloops, and so I definitely get that concern. And so if you can get it on there, what they can do is fill out a most form the next time they're at the doctor's, and let the doctor know that they have an advanced directive, where it is, or they can bring a copy, or you know, you can get a certified copy, or they can just bring their original, and then that can get sent into the system. But my understanding is a lot of the doctors' offices now, it's kind of an inter-agency now, but again, I'm not, I don't get to know as much on the doctor side. They're a little bit gatekeeper about that. So I don't know as much on their end. It would be great to have a little bit more insight onto their side of it from time to time, but yeah. Now, yeah, it's kind of a, NIDIS is good, and I think what they do is good. So I think that it's really a helpful registry to throw things into if you can. So with the representative, you know, if we're talking about somebody with the Section 9, they're going to have all sorts of abilities to deal with. Now, the Section 9, if it's granting power to refuse or consent to healthcare necessary to preserve life, it has to expressly permit it. Like, these things have to be expressly said. I give, or I refuse. My representative may give, refuse, withdraw consent necessary to preserve life. That has to be there specifically. Otherwise, that's not going to be something that they get to do on their own and decide for themselves what that may be. Now, we've kind of talked a little bit about that, where if there is both the representation agreement and advanced directive, representative is going to be using the directions set out in the advanced directive. That's telling them where their lines are. I think probably a most common version, and I mean, again, you can even put this express wishes within your representation agreement, rather than having both. Personally, I think the advanced directive is most beneficial when you have somebody who doesn't have anybody to appoint as a representative. So, you know, you're really wanting to make sure that people understand, if you've got two, this is gonna work with the representation agreement, but it's going to be telling the representative, this is what you have, you know, this is my instructions to you in this scenario, right? And so when we talk about advanced directives in a more specific way, what my biggest concerns with advanced directives are that they are clear enough, right? We want to make sure that if somebody's putting down, I don't want to be kept alive, that they know what the lines are, right? And so sometimes I think the pandemic is a very good example of a situation in which maybe somebody said, if there's no chance of recovery, you know, using the more generic language, you know, if it looks like I'm going to die, just let me die comfortably. Were they contemplating a situation like this, where if I was put on a ventilator, I could get better, versus, you know, just let me go without the ventilator, or, you know, so you really have to have very uncomfortable conversations. I find a lot of junior lawyers struggle with this, is that, look, I'm going to talk to you about death and dying. Anytime I do will instructions, I'm killing spouses off, I'm killing kids off. I'm, you know, like, you have to get really kind of dark about it and find out what people's lines are. And then more importantly, tell them to have that hard conversation with the person they're appointing. And if they don't want to have that conversation with anybody and they want to make the decision for everybody else and make it easier in their minds, I don't always agree with that, but that's their choice, right? Then what I have to say is, okay, let's think about this logically. Sometimes it's simple. You know, if the person's a Jehovah's Witness and blood transfusions are just a no-go, that's clear, right? That's easy to say yes or no to, but when it gets a little bit murky at that end of life, am I going to make it? Am I not going to make it? That's where you have to have that conversation, right? So, yeah, POAs from, oh yeah, yep.
Sorry, there are 2 more questions in the, if you want to answer those as well, and then.
Yeah, yeah, exactly. Yes, Sandra, thank you. Yeah, absolutely. Because some people will get connected, especially clients for example, with us, do get connected quite often with the social worker at the hospital. And so if we can let them know that these documents exist, they can help make sure that it gets tracked. So for sure, absolutely involve social workers. I have nothing but respect for them. POAs from other province that include health reps ever considered legal documents in BC. So it's a little bit kind of a weird conflict of laws type question. If it's a validly executed document in a different province, often it will get dealt with here and accepted here to a degree. If the person, like if the adult is in BC now and is now resident in BC, there's kind of a gray zone of, you know, when should we say, look, you got to have a BC document. That's a little bit of a gray zone. And I think for the most part, as long as it's a validly executed document, to a degree, it's going to work here. If that's the only document ever, it gets a little bit more questionable, right? And so, for example, I mean, even with wills, you'll have to do different wills for different, you know, we should do a will, say you have a vacation property in Alberta. You should do a will for the Alberta property. It's easier to, you know, you can still recognize a BC will. It's just going to be extra steps to have things recognized in other jurisdictions. And so it can sometimes create some problems down the line. You know, so for example, mom lives in Saskatchewan, develops dementia. I want to move her here to be closer to me. She has all the documents ready in Saskatchewan, but nothing here. We're going to try and get everything recognized here before she moves here, so that way the authority's there. But the preference typically is once somebody has become a resident of BC, that they have BC documents, but that's not always possible once somebody's lost capacity. And so you just have to make sure everything's registered. Sometimes that's easier to do, you know, in the home province, say with the bank, you know, do it there, get everything set up and recognized there. And then, you know, especially if it's a national bank, then you can deal with it here. But yeah, it really does depend on on who you're dealing with as far as getting things properly recognized. So I'm just going to take a moment to address some of the questions that talk about or asked about representation agreements and validity of the representation agreements before jumping a little bit further into the I don't have anything document. So I see we've got one live. Many family. So Lynn, so, you know, yeah, so they talked to a lawyer, notary public, and they were, you know, the lawyer wants a letter from the social worker that it's okay to do a power of attorney for the family. I can't speak to how other people do it. I can speak to how I was taught, how I do it, and how I teach others to do it. And that is if a person needs a power of attorney or a representation agreement, it's not uncommon to have family members facilitate that, particularly if they're vulnerable, or we'll have a social worker call to set up the appointment for a person, or daughter or son. We're like, hey, the doctor said we need to do this, so I'm going to book you an appointment. That's great. Everybody should have these documents in their lives. But at the end of the day, the client is the person who is giving the authority away. And so I will only meet with that person for the purposes of taking instructions and executing the POA or the RA. Now, if I'm reaching out to a social worker, it's because I'm just saying, it's not so much like I do care to find out, does this person have an illness or something that I need to be aware of? What's the dynamic of the family like? I might call to get a little bit of information, but I don't necessarily require letters, that I don't normally require letters from doctors or from care teams unless there is something in particular that I want to make sure that I'm noting on my file. But realistically, what I'm more concerned about is does that person that's requiring the document actually want to do it, understand what we're doing, give me coherent instructions, and am I satisfied that they have capacity? So that's usually what I'm looking to do. And I don't necessarily need letters, but every person's a little bit different in how they run a file. Some people really want to pay for a file, particularly in long-term care that the social worker had suggested. Yeah, that's a good idea. And I would too if I were you. I wouldn't write the letter because realistically, it's not your decision to make as whether or not that person can do the power of attorney or not, right? It's the lawyer. Like I said, I would call you to say, hey, I've got so-and-so, what can you tell me about this family? Is there anything sniff testy? Does something smell bad about this that I should be aware of? Yeah, you have to have a monitor. Okay, so I'll get to that one in a moment, Deborah. I think, so Maria, your question, it's not so much that they'll only recognize the will that it's done in, it's just extra steps to have that will recognized in other provinces. It's just easier sometimes to have something that deals with property in other provinces. It doesn't mean you have to, it can help speed the process up for probate after you pass away. That it's easier to confirm the validity of a will in Alberta for Alberta property than it is for BC stuff. Okay, so I'm gonna run through a little bit and say, okay, yes, you should have a second rep or monitor. The reason why with Section 7s they have this secondary person, typically a monitor, is because of that day-to-day financial. It's just monitoring because the person who granted the Section 7 has less capacity. They want to make sure that there is somebody there keeping an eye on the actions of the first rep. We assume with spouses that they're going to act in each other's best interests. We assume, but obviously that's not always the case. But what we really want to make sure is that there is a second set of eyes out there for Section 7s, just because of the limit, the lower capacity of the adult granting that authority. Now, with Section 9, you don't have that monitor because, we're pretty certain, quite certain, in fact, positive, in fact, that this person had capacity to trust the person they're appointing. And also in the Section 9, there's no financial authority granted. So that's the role of the second rep and the monitor, is that it is somebody who is keeping eyes on the representative. So I hope that answers your question, Deborah. Now, in response to social workers, type up both Rep 7 and 9. Anybody can draft a section 7 or 9 representation agreement, and a power of attorney for that matter, and have 2 witnesses. So there's a few questions about witnessing and my voice. These documents, so the enduring power of attorney and the Rep 9, Rep 7, you can have those documents. So the Section 9 and enduring power of attorney, the Power of Attorney Act and Representation Agreement Act say that to be witnessed, it does need to be signed by 2 witnesses in the presence of the person when they sign. So your adult signs in the presence of 2 witnesses who then sign the representation agreement, and that's a valid document. And it's a similar provision within the Power of Attorney Act, but only 1 witness is required if that witness is a lawyer or member in good standing of Society of Notaries Public, Law Society, or a Notary Public. So as long as that's the case, then you're good to go. I will say this: I have had banks who refuse to accept a power of attorney that are not witness. And I see somebody, I think there is a comment here. Yes, there is no way to navigate that because, much like Eric's question earlier, that's the bank's policy. The law says you don't have to have it witnessed by a lawyer, and if you do have it, you only need 1 signature, but that doesn't stop the banks from denying it. And I think it's a really frustrating thing because, if they have determined that they can do their own powers of attorney within branch, who is not a lawyer or a notary, I don't understand the difference there. So that one, there's no real way to navigate that because that's their internal policy for whatever reason. So I think we've got, okay, so Deborah's question was answered. You can, so the Section 7, the person and then also completes a certificate in the prescribed form. So you can have for the Section 7, you can also do the that signing process with the 2 witnesses, but you have to also complete a certificate for your witnesses and your representatives. It's kind of frustrating that sometimes these documents, if they're not witnessed by a lawyer or notary, they're not as recognized, but there's not a lot I can do. I can tell you this much though: if you are helping people out by drafting and passing it to them, what you need to do is make sure that the person who is signing as a witness is not also a representative, right? You can't act as a representative or you can't act as a witness if you're also named in that document, or if that person is a spouse of, so if I appoint my sister, I can't have my brother-in-law be the witness, right? So you just have to make sure that you're really cognizant of that, who can and can't sign. If a person's not an adult, they can't be a witness. So there's all sorts of things where that's really kind of the hard part. So you also have to make sure that I know in the pre-submitted questions there was a question whether or not where is that question? There was a question of whether or not it's valid if it's not signed. So it's not your rep. If you have 2 people appointed in your representation agreement, you have to have at least one of, like, your primary representative has at least signed it, if not both representatives. So the adult has to sign it, and at least one of the representatives has to also sign it, and they can't be a witness as well. So your representative can't be a witness. So yes, my voice is very helpful, especially I don't think any of the documents have changed, but it is very helpful, especially for getting people to think about the kinds of questions they're going to be asked. It's very surprising to a lot of people about the different types of questions that people will be asked when they are talking about the type of care that they're going to give authorization for. Janine, is it possible to end or make changes or possibly revoke Rep 9s? If not, is it possible? I think that was to do any kind of addendum. My preference, just for cleanliness sake, is that if you're making any changes to your representation agreement, and I even apply this as far as like to POAs, it's better just to do a new one because it can get very confusing very fast. But if you are, we include a provision that any changes have to be done in writing by all parties so that everybody understands what's going on. Yeah. So it's really kind of a tricky one. Yeah, so let me just pull up the questions with respect to they're not those certificates for the Section 7, so the rep, monitor, and witness, those certificates are not required for the Section 9 or power of attorney. Our office, we do that just because I like to go over some things with representatives to make sure they understand they're supposed to make best interest decisions and things like that. But yeah, when it comes to that certificate, it's only technically required for sorry, it's only really required for the Section 7. Okay, so the monitor is required for Section 7. Let me just pull up the exact okay, so monitor, if a monitor is required, let me just pop back up here. My understanding is if it is a spouse, then a monitor is not required, but I'm going to have to triple check on that. But that's my understanding, is that a monitor is not required if it's a spouse under a Section 7. But I'll triple check that and get back to you guys. Now, as far as witnesses, so social workers, that's an interesting question. I mean, technically, in theory, because you're paid to assist the person, sometimes it's good not to be a witness, and I think that there's actually like internal rules on that, and just logistically, I think liability wise, I think it's probably appropriate not to be a social worker witness for a client. Yeah, I mean, it's kind of a tricky question. I know that you couldn't be appointed as a representative. I know that much for an adult. But you probably shouldn't also be a witness. But, I think, so as far as the strict rules under the Representation Agreement Act, you could be, but, an employee of or agent of a person that's named in the representation agreement or as an alternate representative, that's, yeah. So under the Representation Agreement Act, you're not prohibited from being a witness to it, but that's a little bit different depending on where you're working and what your overarching policies are that you have to be aware of. And so I would look into that. Yeah, Carly's mentioned into the chat that she's only done it when there's no other options. And I think that kind of relates to one other question that was in the preset questions about expediting, you know, if there's an urgency to getting a document done, you know, how to expedite that in urgent situations. If there's nobody else and you need to get it done and the client has capacity that day, then that might be one way of expediting it. Honestly, the fastest way to get a representation agreement done is to call a lawyer and pay and explain the situation. Yeah, and if somebody can't get in person to witness, there are virtual signing options now. We at the legal clinic don't do it just because of liability and things like that. But it is possible. The law was changed due to COVID, which is kind of nice, that you can do virtual signings now. You know, for us, we do meet with clients over the phone for our intakes, but then the signings are done in person. We have gone to care facilities in the past to witness, but what we have done is we've tried to plan it so that we can meet them outside. So usually springtime is really the best option, but professionally, like in private practice, I absolutely have done house calls, and I know lawyers that do that, or will go to the hospital or wherever. We're a little bit more limited here at the clinic just due to the nature of having students be the ones conducting the file, and so we have to follow health and safety rules through the university here. So if they say we can go into places, we can go into places. So that kind of deals with that question. I can tell you this much: if you need an expedited document, the legal clinic's not always your best option, because again, we are working with students, so things just do inherently move a little bit slower. Eric, I think my voice is probably your best bet, because it's a government approved document. That would be the best to get a template to provide friends or family. Is, you know, if you're doing a power of attorney or something without a lawyer, you know, obviously I always like, it's kind of hard. I mean, we do powers of attorney and wills and representation section 9 agreements here at the clinic, because capacity is not an issue. And so for our clients, if they meet our financial requirements, we can do them for free. So for those of you who have people in the Kamloops area, or know people in the Kamloops area, the legal clinic here can do it. And I think LSLAP might as well. So, and in Vancouver, they might be able to help out. I'll double check on that one too. Just make a note here, but I'm pretty sure that LSLAP can do wills for clients that financially qualify and where capacity is not an issue. So if you have somebody, Eric, that you're thinking might need a power of attorney or will, try and see if one of the legal clinics attached to the university can, you know, UBC, UVic, or us, if you're in the area, we can probably help with that. So yeah, it's I see a lot of responses, so we must have a lot of social workers on this call, so that's great. And nurses. Yeah, you know, it is nice. You don't have to avoid all healthcare workers in the hospital, you know, as a witness, and we've had to do it if there's nobody else available. Like, if, you know, sometimes depending on if you're calling a lawyer, you know, they might bring somebody with them, right? I know the case I was talking about earlier, where they took the lawyer's legal assessment over a doctor's declaration of incapability. It was 2 lawyers that went and did that one. And when I was articling and when I was practicing in Lumbee, my boss, Joe Dooling, and I would go, if there was even a question of capacity, we would both go. We would both take notes and be the witnesses. So it really does depend on the client. So yeah, and definitely make sure you know your own internal policies. Yeah. So I don't have a list of lawyers who are willing to visit hospitals or long-term care homes or homes. It's just, sometimes you just have to call yeah. So sometimes you just have to call around and find out who can. And sometimes, like, I know some people who will do it for certain clients and some people who won't do it for other clients. And yes, Nikki, yeah, it is something. Some lawyers are kind of advising against doing virtual witnessings. It's permitted, like it hasn't changed, that part of it hasn't changed, but a lot of people, I myself included, like I said, we don't do virtual signings because it's the students that are learning how to do assessments, and so it's really tricky to do over Zoom. And most of our clients in the Pottery Law Clinic don't have readily available internet or devices that can facilitate Zoom. I think it's just a comfort thing too, that it's not something that we're really like, yeah, great. It worked for the purpose that it was there for. But I even had a lot of friends that still just set up conference rooms or did signings like in entryways rather than rather than doing the virtual thing. It's just not comfortable for us. And I think there's something to be said for that. So yeah. Yeah, the EPOA, I think, okay, so I answered that one. Agent supply on and off reserves will be more than one rep agreement and financial steps to cancel an agreement. And time frame. I'm not, yeah, so I'm not 100% sure. If somebody can explain that, there's typically not more than one rep agreement, but then again, you in theory could set up 2 different ones, and just very specifically, you'd have to refer to them. That's a very complicated scenario to set up, as far as, you know, can there be more? So yes, there's a representation agreement for medical personal, and then a power of attorney for financial. I hope that's what that question's asking. And then steps to cancel an agreement. If the person has capacity and wants to revoke their representation agreement, they give written notice to the representative. I have taken away your authority. Shred the document and let your care team or whoever has your representation agreement on file know that you've canceled that one, and hopefully have made a new one to replace it. So that's that. I get a lot of questions about, yeah, people are very much so influenced by American TV. I totally agree. We're not the same as America, and I'm gonna get to what one of the big distinctions is in a couple of slides, as far as that part gets. Yeah, financial barriers to get it to a person getting an enduring power of attorney. Look, if you're able to be in the Kamloops area, and we can do an enduring power of attorney for free for somebody, and they financially qualify, please let us do it. Oh yes, and the Access Pro Bono clinic. They have a wills clinic. So there's resources. You just might have to look, or you might have to travel a little bit. I wouldn't recommend a representation 7, like I wouldn't recommend a section 7 if they have the capability to do an EPOA and a Rep 9, just because it is so much clearer to those financial agencies. If it's absolutely impossible, I mean, it's better than nothing. That would be my say on that, is if you can find somebody to help out with doing the POA and the Rep 9, please try and do that over section 7, just because it is really a much better option to do those two. And he said to banks who constantly ask for, again, I don't know what it is with the banks. Yeah, the family has the legal document and the banks don't want to recognize it. Banks. I wish I could say more. Yeah, and supporting family members dealing with representation agreements and their role as representative. Be knowledgeable on the representation agreement itself and the authority granted in that to that representative, because that's really going to make a difference. And then just helping them understand and trying to communicate, if at all possible, like until the very point where the adult can no longer participate in the conversation, they should be involved, right? And so it's hard to have those questions and those conversations, and then when you can't get advice or opinion from the person that you're acting for, yeah, it's a little tricky one. You know, I think it's really helpful just to help them understand, you know, that they're there to act in the best interests of the adults, and let that be their guiding light. Um, and talk to the doctors and the care team to really get a full grasp of the situation, so that you can really make an informed decision. And I think that, you know, if you're acting under a representation agreement, and you've got a client who's coming to you for support with that, they're in a bad way. Somebody's sick and somebody's not doing well. And so I think just, you know, sometimes moral and emotional support is really the best thing you can do for somebody. Now, if a person has no assets, I definitely do still encourage a power of attorney, because they have, you know, they still have bank accounts, they still have to file taxes, they still have to, you know, sometimes make legal decisions. And so the power of attorney is not just about protecting assets or investments. It's about protecting their legal personhood, right? And so if you think about it that way, the power of attorney is going to give you a lot more authority than that Section 7. So Carly, I'm going to look into, I have a spreadsheet with a whole bunch of resources. So I'm going to see if there's anything for Powell River or Sunshine Coast. I don't know anybody who does free powers of attorney up that way. So it might be a run down to the lower mainland for that. But I'll take a look and to see what we could, if there's anybody we can refer you to. Yeah. The will packages from Staples, I'm not a huge fan of them, and the POAs. If you're going to do a POA, I think your better bet is to hop into the My Voice precedent. That's the government one. The problem with packages from Staples is that they're built for kind of like an across Canada sale. So they don't really take into account the specific laws necessarily to BC, because BC has different wills and power of attorney legislation than Alberta and Ontario, and you know, so it is, but again, like, it's going to be better than nothing, right? So it's that speed, expediency versus just getting something out there to make life a little bit easier after that person's gone, when it's a will, or to try and make some decisions while they've got a power of attorney. Discharge locations. Yeah, so yes, absolutely. A representative can make a decision about entering into long-term care, for sure. So if we're worried about their ability to care for themselves, there's two routes that you go through. And so one would be, you know, if you have a representative, they can make that decision about long-term care if the adult can't consent. Ultimately, the adult's going to be the person making the consent. The other thing to consider is it an appropriate use of the Adult Guardianship Act, the protective measures under the Adult Guardianship Act, and to see if they need to be kind of held into custody. But then you're ending up in provincial court, and all sorts of fun things can happen there. So I do recommend it. Ultimately, if there is a very serious concern that this person's not going to be able to care for themselves, and that part is going to be triggering that representation agreement, there's that line, right, of individual patient consent. We don't have to agree with their decisions or like their decisions. It's their decisions if they can make them. So it's kind of that tricky gray zone. Yes, I am gonna get to that. Deborah, yes, Vancouver. I would, Nikki, I would look at the Law Students Legal Advice Program, LSLAP, at UBC. They have a clinic. Who would do free EPOAs for seniors and low-income seniors? Well, we could, if you're in Kamloops. So that would be, you know, if we could, we'll definitely help out. And again, I think Legal Aid has a pretty good resource bank for some of those people. And I'll double check, but I think LSLAP on the Lower Mainland might. Yeah. Okay. Let's see. It doesn't, Courtney, it doesn't need to be witnessed by a lawyer or notary. It's just kind of going back to that question of the banks, right? If the power of attorney is not witnessed by a lawyer or notary, many banks will not recognize it. It doesn't mean it's not valid. It just isn't necessarily recognized by the banks. The power of attorney act says it just needs to be 2 witnesses that watch the adult sign the power of attorney, and then the 2 witnesses sign, and the witnesses can't be the people appointed within, and they have to be capable and adults themselves. POA does end at death, and then that's when the will takes over. Thank you, Eric. Law Center in Victoria does POAs and health reps for free or low income. Excellent. That's great. Yeah, so the power of attorney's the attorney's authority ends at the time of death, and they should be doing an accounting and passing everything over to the executor in the will. And hopefully there is an executor. And if there isn't an executor, then someone's going to have to step forward to do it. We always keep a copy on file, but what you really need is the original. So you need to make sure your representative or your attorney knows where the original is kept. My practice when I was in private practice was to hold originals unless the adult came to me and said, I want my original. Great, here you go, sign it out. You took it. It's not mine anymore. Your responsibility to take care of it. Or the representative or the attorney, has confirmation that they need to act at that point. And so I'm not sure how many people are out in the Kootenays for doing it for free, but I'll look into it. I know there's a lot of good advocates out there, so I'm not sure if they're available. Okay, and I think I got those last 2 as well. So I think that answers most of the preset questions. Yeah, so Vivian, I'm so cannot make, so you said it is a rep agreement until rep agreement POA. So as a decision, I'm going to get to the temporary decision makers. So let me it's always typically going to be the representation agreement that is what's looked to for who's going to be making the decision. So I'll hop back into these slides. So the representative, so we go the patient, then we're going to the family, to the representative. Now what happens if there is no patient ability to consent, there's no advance directive telling what kind of care is to be provided, and the representative hasn't arrived yet, or there isn't one, you're going to look to the temporary substitute decision maker. And it's the Healthcare Consent Care Facility Admission Act. That's the document that tells you who do they go to for care decisions. And that's section 16 of that act. So the temporary substitute decision maker, the TSDM, excuse me, that is the stand-in until either the adult regains capacity or a representative, or if there is a guardian in place, and I'll kind of hit on that in a moment. Then that's there's a hierarchy that the care team is going to look to, the healthcare provider is going to look to. So section 16 tells us that the list, and they're listed in order. So this is why you tell people, look, if you care who makes the decisions, because some people, when they find out the hierarchy, this is why it's really important to have a representation agreement if you care who makes the decisions. So first is the spouse, then an adult's child. That can create problems, right? Like, what if some of the kids don't get along? Which child, right? It's not fun. Now, if there's no spouse or children, then the adult's parent. If there's no parent, then a brother or sister. And what if you don't agree with them or they don't agree? If you don't have any brothers or sisters, then they're going to go to a grandchild. There is no order, Courtney. There's no order to which child. It doesn't say. But there's some more conditions. So I'll go through this hierarchy first. Then we go grandchild, anyone else related by birth or adoption to the adult, then a close friend of the adult, or a person immediately related to the adult by marriage, so like an in-law. But to qualify, here's where we get the fun part is the person has to be at least 19, has to have been in contact with the adult in the preceding 12 months, that they're not in a current dispute with the adult. They themselves have to be able to give, refuse, or revoke consent, and be willing to comply with their duties. And so they're the best interest decisions, known wishes are going to trump everything else. And they have to meet those duties. Oh, it looks like I didn't finish the sentence. Sorry. So they have to be able to fill their duties as the representative. So best interests and acting in good faith. So that's really, where we kind of have all of these people have to be gone through, and they have to meet all of these qualifications that I just listed off, and they get the ability to make decisions, and they have to get all the information or documents that they would need to make an informed decision. And so I mean, there's all sorts of things to consider. Now, if nobody can meet that, if there's nobody listed, or nobody qualifies, or if there's a dispute, this is where, unfortunately, it's the healthcare provider is then forced to choose a person, and this could even be a person in the office of the public guardian trustee as authorized. Now, I don't know about you, but I don't know many healthcare providers that want to be the person to choose who's going to make those decisions. So what they have to do is what they're required to do is to make a reasonable effort in the circumstances to comply with following that section. Now, we referred to section 18 a little bit, and so these are restrictions on that. So there's is it care necessary to preserve life, and the consensus with healthcare providers. So is it medically appropriate? Is the decision made in accordance with section 19? So did they consult with the adult if possible? Was there a family, close friend, or relative, or if applicable, somebody appointed by the PGT that was consulted? And is it in the instructions or wishes of the adult? And if you don't know the wishes or instructions of an adult, what is their best interests? And so that's kind of a weird one. What are their current, do you know what their current wishes were? Do you know what their known beliefs were or values were? So like, it's an easy one to go to, because it's a fairly well recognized one, with where you have somebody who is a Jehovah's Witness. If you know that they wouldn't want a blood transfusion, you shouldn't be consenting to it, right? Because that goes against their beliefs and values. But is there a chance of recovery? Is there a benefit outweighing the risk? There's all sorts of those considerations. Is there a less restrictive or intrusive form of care? So these are all the kinds of things where you really are trying to figure out what those wishes are for your person. So if you're looking at that, it's exhausting. I can't imagine being a section 16 committee of so section 16 is temporary substitute decision makers. A committee is a guardian. So if you don't have a guardian, so if a guardian hasn't been appointed, so you don't have a committee, you don't have a legal representative. So a committee is a person who is appointed by the court. That's you can't do a representation agreement. You can't do a power of attorney. Someone has the money, time, and ability to apply to the court to be appointed as your committee. Section 16 of the Healthcare Consent Facilities Act is if there is no legally appointed representative for you. So a power of attorney and a representative would get superseded by a committee appointment. So committee requires, basically they're really, I'm trying to determine here if I've got that. So outside of representation agreements and powers of attorney committees, what you end up having occur is somebody has made an application to the court to be appointed the committee of either person or of finances or of both. And that requires 2 doctors' affidavits confirming that this person is incapable for X reason of taking care of themselves or their finances or both, that there's no chance of them regaining that ability. And so when we say in this section, you know, if there isn't a guardian, like the stand-in until the adult regains capacity or the representative or guardian arrives, that includes a committee. And so that person then, so when you're going through the process, a person applies to be appointed by way of a petition to Supreme Court. When that happens, the process is to gather affidavits in support. Kindred and fortune is, I think, the formal term for it. And that's where if there's other family members, they say, yeah, we agree with this application, or we don't want to do it, please let them do it. That application, that petition material is vetted by the public guardian and trustee. They usually take no position, but what they will say is, yep, that's fine, but we want you to add in a provision to the order that if there's a sale of a family of the adult's home, that has to be approved by us first, or we think that you should put up a bond, you know, a monetary bond. So if you don't act right, then you know you forfeit that. But and then you go in front of a justice or a master of the Supreme Court. They review the material, and if there's no opposition, they typically grant it, so long as you incorporate the PGT's requests. And that person, that process essentially has essentially rendered the adult, and this is why it's very it's not taken, it shouldn't be taken lightly. That person is essentially rendered incompetent legally, not just medically, but legally recognized as incompetent, and essentially their legal personhood is taken away from them. They have no more say in their life. Now, this goes back a little bit to that Americanized viewing of everything, and where they have to say, okay, so you're appointed as a guardian. So Britney Spears, right, is the prototypical example right now, where she had no legal authority in her life, right? And so this in BC. We treat this as like, this is a finality type thing, right? Like there's no coming back typically from something like this. And so it's really not taken very lightly by the courts because of what you're doing and removing that legal personhood. I think there's been a bit of a move towards more supported decision making rather than just like substitute decision making. And that's the subject of a whole nother talk. But if you have gone through that process, because somebody needs to make decisions, for a lot of our clients, they don't have the ability to do that. And so really what we're talking about in the committee application is, it's an expensive court application, and not a lot of people can afford to do it. If you have gone through that process and you're helping a family or a patient in that scenario, that person, it's almost like, so whoever's appointed at the committee, they are that person's guardian, just like you would with a child, right? And so they are the decision maker. They are that legal person. It's more, I'm not going to say important than a power of attorney or a representation agreement, but it would supersede that, right? It would replace that. So your committee application, you are the representative / guardian of that person. And so you would be under that first category. So if the patient, like if we go back, you know, a couple of slides, they would be in this category here, you know, with the representative. So it goes the patient, the representative, temporary substitute decision maker. You would count the representative, you know, that's where we would slot the committee in that scenario. So that's the committee. So yeah, an adopted child, You know what? So Trisha, as far as the law is concerned, if it's a legal adoption, they are a child. So as long as it's a legal adoption, they're the same as a biochild. They are a child for all intent and purpose. It doesn't specify how you decide which child. Then that goes to number 3 under section 16 of the temporary substitute decision makers, which is, you know, which child. Well, I guess we're going to have to let the healthcare provider choose, or have somebody from you know, give some guidance on that. Now, if they haven't been in touch for the past 12 months and there's nobody else, I mean, it's still really like they're technically not going to qualify under that, right? They have to have been in contact with the adult for the preceding 12 months. It's a prescriptive, so it's in the legislation, and I mean, the healthcare provider might speak with the public guardian trustee about that, and I would look for that guidance before I would make that move. Luckily, I'm not the one who gets to make these decisions. I don't have to be in that hard part. I like what I like to do, which is the representation agreement, powers of attorney, the preventative lawyering, I like to call it. You know, it's like taking a vitamin, take the vitamin or take the medication to prevent further illness, right? That's what I consider wills and powers of attorney in advance and representation agreements. So yeah. The only child attains age of majority, wants to take over care and requests to have a new agreement. Well, I mean, Vivian, the reality is it depends on the scenario. If the adult who is the subject of this POA or RA wants to do a new one, yeah, do a new agreement. But if the only reason why a new agreement is being considered is because the child wants that done, it's not the child's decision to make. It's not their life. It's the adult's life, right? So as long as the person can really do, as long as the person wants to make that change, that's up to them to do. So I leave it up to that. And you ask if they've done advanced care planning. Yeah. Yes. Yeah, if they are, yeah, ask how old they are for sure. I think it's important. And I also, just to add on them, start thinking about who are your alternatives, who are your reps, right? Like, just, you know, you want to make sure that everybody's going to outlive you, right? That's really the big one. So it's kind of an interesting one. There was a question from Vivian about being for a child, but there are guardians for children, and that definition of guardian is not the same as comma T. It's that's more of like a, you know, a parent or a legal guardian. 2 children, and they don't agree. Yeah, so that's where, yeah, if people aren't agreeing, I mean, the healthcare provider is going to have to choose a person. Unfortunately, that may actually end up with people in court making a comma T application to just be appointed the legal guardian, because at some point somebody's got to make a decision. Yeah, and the cost. Yeah, and technically it is the adult's document. In some cases they do get reimbursed for that. $6,000 is quite a bit, in my opinion, if it's a simple one. At least that's interior thing, you know, interior BC, that's where that process lies. So it really does depend on that scenario. So but yeah, I wouldn't be surprised about $6,000, because you are getting doctor's affidavits, you are in Supreme Court, you are dealing with PGT, and of course they charge a fee for doing that service. So it is a tricky one. Now, when we talk about who are these people, so if it's a family member that's not available, who are we talking about, right? And so when we talk about the close friend, we look at that definition. And the definition of a close friend is another adult who's got a long-term personal relationship, and they interact on a regular basis, and they don't get paid to do this, right? You know, that's always the key. They're not getting paid to be friendly with this person. They're just friends. A near relative is somebody, you know, where it's a parent or grandparent or brother or sister, or somebody who's in relation, connected to one of those closer relations to you. So it could be a spouse, or it could be a child of one of these people. So like a niece or nephew kind of thing. Now the spouse, of course, is somebody who is either married to that person and not living separate and apart, so they're not in a point of separation, or is living in that marriage-like relationship. And so those can get very messy very fast, and sadly that's things that end up finding their way into court to determine who will make that decision. Now obviously the care has to be done to a degree, and that's where you end up starting to have the PGT step in if there's really no resolution. So to sum it all up, we're going to go, the patient is the first person who gets to decide, and they might have an advanced care directive that will help with that. And do they have the capability of contributing to the care planning? If they're not in that position and the advanced care directive is silent to the care that's being sought, then we look at a representation agreement. Is there, the legal representative of the person? And so, is there a personal guardian or committee? Is that Section 7 or Section 9 representative? Do they have that authority within that document to make the decision? If some clients like to say, I want this person to be able to only say no to this care. They can't say yes to the care. They can refuse consent, but they can't give consent. And so you have to, go through that, a little bit with a fine tooth comb to really make sure it's very clear to not only the representative what they can and can't do, but also for the adult to understand, okay, well, if you say that they can't give consent, what about in this scenario? So it's all about going back and forth of making sure the client understands the implications and consequences of that Section 9 representation agreement in particular. And then the temporary substitute decision maker, they step in if the patient can give informed consent and there is no representative or guardian available to make that decision. And then in that case, that's where we get to follow that super fun hierarchy of who knows what. So, yeah, there's a bit of a Passover sometimes, and it really does come down to that understanding and informed decision for the adult. And if they can't give oral consent, can they give it in writing? Is there an advance directive? What if the representative is not expressly permitted to make that decision? So if we think back to components of that Section 9, if it's not expressly written that their representative can give or refuse consent to life-preserving treatment, it's not saying that specifically, then how do we, how do we look to that? So we're going to be looking, to whether or not that the representative applies to be granted that authority, or they might have to apply to be a committee at that point to make that decision. But if it's urgent, are we going to have to then look to a temporary substitute decision maker? What does that look like? And oftentimes that leads us to my most annoyed but also favorite place of seeking guidance from PGT or subsequently the courts. So I think I want to just make sure that I've answered a lot of these questions. If you have questions about formal agreements, definitely, you're welcome to call. Depending on the nature of the question, sometimes I'll just take the call, or if it's, usually social workers and that, if they're giving a call. But we also like to try and run some things through the students so that they get the opportunity. So depending on the nature of the question, sometimes I'll take the call and I'll just talk with you, or we'll look at doing a conversation with the student to do that. Yeah. I think the big takeaway from my perspective is often to make sure that people a completed Rep 9 agreement. I think that there's some examples in that My Voice, but I'll you know, it's kind of a tricky thing for me to do because everything's so unique. You know what I mean? If you have access to the continuing legal education website, and I think you can get to that free from any courthouse library computer, they have samples of that as well. Mine are so like weird in that they're kind of built out for very specific clients. I'll have to take a look and see if I can find something as like an example, but like, I mean, I often leave them fairly wide breadth until I have instructions. So my basic examples are very, you know, they're kind of an omnibus of everything that you could possibly put into, plus some. But I think, like, honestly, like my voice is a strong base point to look at for a sample example, and it's the one that the government has kind of built on based on their understanding of the legislation. So I'll see what I can look at. But are there any other questions? I feel like it's always so much information that I try to push through. So if you have any more questions, definitely please let me know. But otherwise, I think that was my last slide. Yeah.
Thank you, Kelly. It was certainly a lot of information. Kudos to you. You answered 53 questions in total.
That's my best yet.
I think you've done. There is another question, I believe.
Oh, excellent.
Just now. Oh, it's a comment to you.
Oh. Guys, I need to get out of my office at some point. My head's gonna be too big. I think I think like the big thing for me with representation agreements and powers of attorney, you know, at the very least, yeah, there was the questions of, you know, if they don't have anything, or if they can't afford one, maybe they should just do a Section 7. I don't disagree, but the preference, of course, is if you can find somebody who can do it for free or cost effectively. There's also Access Pro Bono has their lawyer referral program, and there are lawyers out there. You just have to maybe be patient. You know, their lawyer referral program does connect you with some lawyers that can do it for cost effective ways. But, you know, I think to avoid, like I said, preventative lawyering, you know, to avoid the expensive committee application, like Eric pointed out, sometimes if you can find somebody who's willing to do it for a deal, or, you know, if you can save up a little bit, because I think at least here in Kamloops, I think a power of attorney is about $200. So, you know, I mean, it's a lot cheaper than a committee application, I can tell you that much. But it's more fun to work on a committee, but it's really not, because it's really sad at that point. Yeah.
I think there's lots of comments coming to you about the great presentation you have done. I really give it to you. Honestly, I was hearing all the information, and I think I could only consume not even half of it. So I need many sessions to consume all the information.
Yeah.
And before our attendees, they are planning to leave, I just want to say that we have a survey, which a link will be posted by end of this session. Please fill out that survey. That's a feedback survey. We want to hear from you, how our speakers are doing, how we are doing, what changes you want, what other topics you need to learn, what kind of training you want. And there is a prize associated with this survey. So whosoever will win the prize, they will get it through email. You'll get your gift card through email. So please fill out the survey. It's helpful for us. It's helpful for our speakers, or wonderful speakers like Kelly, just to know what kind of other information and which format you are looking into information. And Kelly, if you can send the PowerPoint to us, we will post it. We'll send it to the attendees, as almost everybody asked for your PowerPoint presentation.
Yeah, I'll do that as soon as we get off the call.
Yeah, and if there are any other questions, Kelly's there, although I think she's tired, and it's like good 2 hours of speaking for her. But if there are any questions, if you want to take advantage of it, ask one more question from her or so, you can ask her. And to Kelly, I again say that I give it to you. It was a wonderful presentation, a lot of information and a lot of questions. I must say good interactive participants you got, that they
Yeah.
kept you going through the presentation.
Yeah, it was good. As you can tell, I like talking about these issues. So.
Oh, I think Bowginger froze.
Oh no, okay, I thought it was me because normally it's my internet.
I think
It's kind of coming back, but perhaps I guess on behalf of Bowginger and everybody at LABC, thank you, Kelly. Thank you so much for being here and just sharing with us all this information. A ton of thank yous in the chat, and thank you everybody for attending.
Yeah.
We will post a recording of this on our YouTube page, but if you also visit our legalaid.bc.ca website, we have a community workers section where we do post training videos such as these, and you also find other resources, maybe publications that can help you or the individuals that you work with. So thank you, everybody. I'll just sign off here now, and Kelly, we'll see you next time.
You betcha. Thanks, Sarah.
You're
Bye,
welcome.
everybody.
Bye, everyone.